Hello everyone, this is Niharika. Welcome back to my YouTube channel. And here is my topic on patentability and process of patenting. Let us see the introduction to patents. Definition of patent. A patent is a form of intellectual property that provides legal protection for an inventor's original invention, ideas, or processes, ensuring it cannot be made, used, or sold by others without permission. Then comes the purpose of patent, that is, patent grants inventors exclusive rights over their inventions for an specified period, usually up to 20 years. This exclusivity incentives innovations by allowing inventors to benefit financially and intellectually from their creations. Let's see the types of patents. Utility patent, design patent, and plant patents. Utility patent is these are the most common type of patents granted for new and useful inventions or discoveries. They cover processes, machines, articles of manufacture, and compositions of matter such as chemicals or parasiticals. Patents protects the functional aspects of an invention. Then comes the design patents, that is granted for new, original, and ornamental designs of an article. They protect the unique visual qualities or appearances of a product rather than its functions. For example, the design of a smartphone or an unique furniture shapes may qualify for a design patent. Then comes the plant patents, that is issued for inventing or discovering and asexually reproducing a new plant variety. This includes hybrids and genetically engineered plants, provided that they are not naturally occurring. Plant patents protect the unique characters of the plant. Here comes the importance of the patent. That first comes the protection, incentive for innovation, then comes the market advantages. Protection. The patent serves as a powerful legal shield preventing others from marketing, using, selling, or distributing the patent's inventions without permission. This protection helps inventors safeguard their innovations from unauthorized use, ensuring they maintain control over their work. Then comes the incentive for innovation. Patents provide exclusive rights to innovators, typically up to 20 years, allowing them to be benefit financially and gain recognition for their inventions. This exclusivity encourages research, development, and creativity by rewarding inventors with a temporary monopoly on their inventors. Then comes the market advantage, that is, patents can give companies a significant competitive edge in the market. With patent protection, innovators, companies can prevent the competitors from replicating their products, processes, potentially resulting in high returns, band different differentialities, and enhanced market positioning. Let's move on to the patentability requirements. First comes the novelty, non-obviousness, then utility, disclosure requirement. First comes the novelty. The invention must be new and not publicly known or disclosed before the patent application. This means the invention must not have been previously patented, published, or in public use. Then comes the non-obviousness. The invention should not be an obvious improvement or an modification of an existing innovation to someone skilled in the relevant field. It must demonstrate a level of creativity or innovation beyond simple modification. Then comes the utility. The invention must have an practical utility or usefulness. This means it must be capable of being used or applied in some beneficial way. Patents are only granted for innovations with a real world application. Then comes the disclosure requirement. That is, the patent application must include a clear and detailed description of the invention. This requirement ensures that someone skilled in the field could replicate the invention based on the information provided in the patent application. This transparency advances the public knowledge. Here comes the exclusions from patentability. First comes the abstract ideas. The concepts that are purely theoretical, such as mathematical formulas, algorithms, or mental processes, cannot be patented. Patents are intended for practical applications, not for ideas that lack a physical or tangible implementation. Then comes the natural phenomena, that is, naturally occurring substances or phenomena such as minerals, plants, or even newly discovered genes are not eligible for patents. These items exist independently of any human inventions and are considered public resources. Then comes laws of nature, that is fundamental specific principles or natural laws like gravity or thermodynamics cannot be patented. These laws are universal truths that belong to everyone and cannot be claimed as an intellectual property. Then comes the legal or an offensive materials, that is inventions that are legal, illegal, immoral, or offensive, such as those promoting harmful substances or unethical practices, are ineligible for patents. Patent laws generally exclude inventions that may be deemed harmful to society. Here comes the patent process overview. Idea to application, that is patenting process being with an innovative idea. The innovators must develop this idea into a fully defined invention and prepare a detailed patent application, which includes the invention's description, claims, and drawings if needed. Before filing, through patent search is conducted to ensure the idea is novel. Then comes the examination. After submission, the patent office, such as USPTO, EPO, etc., conducts a formal and substantive review of an application. This involves checking for an compliance with patentability criteria such as novelty, non-obviousness, and the utility. The examiner may issue office actions requesting clarification or amendments. Then comes grant or rejection, that is based on the examination. Grant means if the invention meets all the patentability requirements, the patent is issued, granting exclusive right to the inventor. Rejection, if the invention fails to meet criteria, the application is rejected. The inventors can appeal the decision or make modification to address objections. Let's move on to how patent rights is maintained. First comes the renewal fees. After a patent is granted, the inventor or a patent holder must pay periodic maintenance fees, that is often annually or at specific intervals, to keep the patent in force. This fees ensures continued protection for an invention throughout the patent term. Then comes the patent term. Utility patents typically last 20 years from the filing date, while the design patents may last 15 years from the grant date. Then comes the plant patents have a similar duration to utility patents, that is 20 years. The patent term ensures inventors have significant sufficient time to benefit commercially from their inventions. Then comes the consequence of non-payment. Failure to pay renewal fees results in the expiration of the patent, meaning the invention falls into an public domain. Once expired, anyone can freely use, produce, or sell the inventions without the patent holder's permission. This enhances the importance of the timely payment to maintain exclusivity. Let's see a brief summary about the patentability and process of patenting. That is, patents are a vital form of intellectual property that protects inventions and ensure exclusivity for inventors. Key aspects of patentability includes novelty, non-obviousness, utility, and adherence to disclosure requirements. The patenting process involves steps such as conducting a search, preparing the application, examination, and grant or rejection. Proper maintenance through renewal fees ensures continued protection. Here comes the importance of patents. Patents promote inventions by rewarding inventors with exclusive rights, encouraging creativity and research. They provide an competitive edge in the market, enabling inventors and the businesses to maximize the commercial potential of their inventions. By protecting intellectual property, patents contribute to societal progress and technological advancement. Here comes the closing note on the patent, that is, patents are not just a legal instruments, they are engines of an innovations that drive progress and empower creators. Encourage the audience to explore patenting as a tool to safeguard their inventions. So, thank you for watching my video.